At Stage, we value our customers and our associates, and we're committed to building good working relationships. One of the ways we build good relationships with associates is by keeping the lines of communication open so that we can quickly resolve work-related problems. But sometimes communication breaks down, which can result in misunderstandings or disagreements that can weaken the working relationship. Unfortunately, in today's society, many employers have seen these disagreements escalate into serious disputes that end up in court. Litigation has become a common way to resolve employment disputes, creating an enormous impact on the employee, his or her family, and the company's resources. While the number of employment disputes at Stage is small, we are spending more and more time resolving these matters in court. We believe our resources are better spent serving our customers and associates. So we've come up with a better way to deal with employment disputes, a better way to resolve disagreements and make things right. We've developed a 4-stage process for opening up the lines of communication and solving workplace problems quickly and fairly. We call this program the Stage Dispute Resolution Program. This program is a mandatory condition of your employment, and it affects your legal rights in resolving employment disputes. By accepting or continuing employment with the company, you'll agree to use this process to make a final and binding decision on all covered disputes that relate to employment by the company. Our program has 4 stages: open communication, formal review, mediation, and arbitration. Each stage must be followed in sequence so that we have every opportunity to work together toward an agreeable solution. The first stage in the Stage Dispute Resolution Program is called open communication. When you have a problem at work, talk it out one-on-one with the person involved. It may be a co-worker, your supervisor, store manager, or department head, or someone higher up in the chain of command. But solve the problem early, before it becomes a crisis. Any door at Stage is open to you. Just ask the regional or corporate human resources department if you need help deciding who to talk to next. If Stage 1 of the Dispute Resolution Program doesn't solve the problem, it may help to get another person involved in the process, to listen to both sides of an issue, and to offer some fresh ideas. If you've already talked with your immediate supervisor or someone else in management and still feel that your questions have not been answered to your satisfaction, you can request that the Corporate Human Resources Department get involved. This process, called a formal review, is the second stage in the Dispute Resolution Program. To request a formal review, simply complete a request for review form available from store management or the corporate office. Once your form is received, someone from the Human Resources Department will investigate the situation as promptly, thoroughly, and confidentially as possible. An HR representative may also meet with you or any other person involved to offer potential solutions. Let's review the first 2 stages of the Dispute Resolution Program. If you have a work-related problem, talk it out with the person involved. If you and the other person can't resolve the problem together, get another person from management or human resources involved. Like Chris found out at his company, you just might be surprised with the results.
Last month I was having a problem getting to work on time. You see, my mother had surgery on her knee and she needed my help. I would have liked to hire someone to help take care of her, but home nursing is just too expensive. I had some credit for some paid time off of work that I used right after my mom's surgery, but later, getting her to her physical therapy sessions on time kept me from getting to work on time. I requested some additional time off, but my supervisor told me that he was just too short-handed. I told a friend at work about my problem, and she told me about a new problem resolution program. She said that if my supervisor and I couldn't settle a work-related problem, I could request a review by the Human Resources Department. Now, I don't like going over my boss's head, but I didn't want to lose my job, and I really needed to help my mom. So I put in a request for review form, and my boss and I had a meeting with Karen from the Human Resources Department. Karen told my boss and I about a law which allows me to take time off to take care of a seriously ill parent. She listened to both sides and came up with some really good suggestions. My supervisor and I agreed that I would try to schedule my mother's appointments as early in the day as possible, and he would change my hours temporarily. As soon as my mother's treatment was done, I could go back to my regular schedule. As I see it, this problem resolution program really works. I was able to help my mom when she needed me, and my supervisor was also satisfied with the solution.
It's really easy to air out your concerns once you open the lines of communication. Talking to each other can solve problems. When each party hears the other point of view, understanding increases, and so does the likelihood of reaching an agreement. Sometimes it helps to get a neutral person involved, someone from outside the company, someone to help both sides reach agreement by listening and making suggestions. This is where the third stage of our dispute resolution program can help. This stage is called mediation. In stage 3, a professional mediator listens with an open mind to both sides of the story. The mediator does not make a decision, but can offer another trained perspective and an independent ear. He or she will ask questions and then offer creative solutions to help you and the other party reach an agreement. But sometimes a problem can't be resolved through mediation, and the disagreement requires a final and binding decision from a person outside the company, a person who knows the issues and has the experience and expertise to make wise, fair judgments. This process is called arbitration, and it is the fourth and final stage in our dispute resolution program. Arbitration is a method for protecting your rights, just like courtroom litigation, but with a lot less time, money, and hassle. Basically, arbitration is a hearing conducted by a neutral outside arbitrator who, like a judge or jury, makes a final binding decision based on the facts presented by you and the company. And the arbitrator can make damage awards just like a court of law. The arbitration process is pretty simple. Once your arbitration request is received, you and the company will work together to jointly select an arbitrator. Then, that arbitrator can talk to both sides and gather information. Next, a hearing is held, usually in an office which is convenient to you and much more pleasant than the formal environment of a courtroom. During the hearing, facts are presented and testimony is given. You may even bring a lawyer if you wish. The arbitrator then makes a final and binding decision, similar to a judge and jury in court. Working out problems with an expert through arbitration has many benefits over going to court. Less for lawyers, more for you. Protected rights, fast decisions, fair decisions, better relationships. Count the advantages, and just like Claire found out at her company, you'll see that arbitration makes sense.
I'm not old. At age 57, I still have a lot to offer. Last summer, 2 corporate office jobs opened up, and I applied for the jobs. But both times I was overlooked for somebody younger and without the years of experience that I had. My boss and I discussed the situation with the human resources representative. We even tried mediation. The mediator listened to what the corporate office had to say and then to my side of the story and tried to help us reach an agreement. I also listened to what my boss and the human resources representative had to say, but I still thought that I hadn't been treated fairly because of my age. I thought about leaving, but I really liked this company and I wanted to stay here. So I decided to take my case to arbitration. You see, I could bring a professional arbitrator in from outside and they would listen to my story. And if I was right, the company would be required to give me the promotion that I wanted, as well as any damages I may have had. So I applied for arbitration. I filled out the necessary form. After about a month, a hearing was held. And I was able to tell my side of the story to someone who knows the law and has experience in work-related problems. And the company representative explained the other side. Well, the arbitrator listened and then made a ruling. I didn't win, but I did learn a few facts. I realized that I had the experience, but I didn't have the computer knowledge and certain other skills for the jobs I wanted. Arbitration cost me some money, but I didn't lose my job. And I didn't spend years working with lawyers and waiting for a decision from the court. And I haven't given up. I've applied for my company's management assessment program. They'll help me map out a career path and identify the additional training and skills I need to get there. I figure that once I develop a few new skills, I'll have a good chance of getting the next promotion that comes along.
In the past, employment disputes could result in courtroom litigation, a process which forced the company and associates to spend significant amounts of time and money, and close the lines of communication by drawing clear battle lines. But today, we have a better way. Most problems can be resolved internally by discussing the problem with the other person involved, or by getting assistance from the Human Resources Department through a formal review. Some problems may need outside assistance, such as mediation or final and binding arbitration. Your problem may be solved in the first stage or all four. With our four-stage dispute resolution process, you have a much less expensive, faster way to resolve work-related problems. In short, it's a better alternative. Your rights are still protected, and the process is so much better. The Stage Dispute Resolution Program is the mandatory procedure for resolving work-related problems. Please take time to read the program booklet you'll receive. It provides much more detail about the Dispute Resolution Program stages and the types of claims or disputes that are covered. You'll find that this program is designed to open the lines of communication and resolve problems quickly and fairly. And by doing so, we can build trust and strengthen our working relationships.